So here I'm going to start Indian polity with the help of Arihant Bok Manohar Pandey, and I'll complete this audio in two audios. Okay. So very first, making of the constitution. The idea to have constitution was first given in 1934 by M.N. Roy. Then Constituent Assembly of India set up under a cabinet mission plan of May 16, 1946. Composition of Constituent Assembly. The original Constituent Assembly constituted of 389 members, and then after, three main communities are there: Muslim, Sikh and General, in the proportion of to their representative populations. Then Constituent Assembly was a partly elected and partly nominated body. The members were indirectly elected by the members of provincial assemblies, who themselves are elected on a limited franchise. The first meeting of the Constituent Assembly took place in December 9, 1946, with Dr. Satchidanand Sinha as its interim president. Dr. Rajendra Prasad and H.C. Mukherjee were elected as its president and vice president, respectively, on December 11, 1946. B.N. Rao was appointed the constitutional advisor of the assembly. On December 13, 1946, Jawaharlal Nehru moved the historic objective resolution in the assembly. It was unanimously adopted by the Assembly on January 22, 1947. One very important thing: whenever the Assembly met as the constituent body, it was chaired by Dr. Rajendra Prasad, and when it met as the legislative body, it was chaired by D.V. Mavlanka. Very important thing, that national flag was adopted on July 22, 1947. National anthem was adopted in January 24, 1950. National song January 24, 1950, and it elected Dr. Rajendra Prasad as the first president of India on January 24, 1950. There are some important committees: Union Powers Committee headed by Jawaharlal Nehru, Union Constitutional Committee, Jawaharlal Nehru, Provincial Constituent Commission Committee, Sardar Patel, Drafting Committee, Dr. B.R. Ambedkar, then Steering Committee, Dr. Rajendra Prasad, then Rules of Procedure Committee, Dr. Rajendra Prasad, Ad Hoc Committee on National Flag, Dr. Rajendra Prasad, headed by this committee. These are drafting members' name: Dr. Bhimrao Ambedkar as a chairman, and Gopala Swami Iyer, Ladi Krishna Swami Iyer, then K.M. Munshi, Sayyid Muhammad Abdullah, then N. Madhav Rao in place of B.L. Mitra, who resigned due to ill health, and D.P. Khetan, replaced by T. Krishnachari after Khetan's death in 1948. The constitution adopted on November 26, 1949 contained a preamble, 395 articles and 8 schedules. Now these are 12 schedules at present. Constituent Assembly took 2 years, 11 months and 17 days to complete the constitution. During this period, it held 11 sessions covering a total of 165 days. Although constitution was ready on November 26, 1949, but was delayed till January 26, 1950, because in 1929, on this day, Indian National Congress demanded Purna Swaraj in Lahore session. Let's recap very fast schedules of constitution. First schedule describe about states and union territories. Second schedule is talking about salaries of president, governors, chief justice and judges of high courts and supreme court and speakers and all. Then third schedule is related with forms and forms of oath and affirmation of union ministers, CAG and high courts judge and all. Then fourth schedule is allocates seat for states and union territories of India in Rajya Sabha. Then fifth schedule, administration and control of scheduled areas and scheduled tribes. Sixth schedule, provisions for administration of tribal area in Assam, Meghalaya, Tripura and Mizoram. Seventh schedule related with the giving allocation of powers and functions between union and states, and contain 3 lists: union list, state lists and concurrent lists. Then eighth schedule is related with list of 22 languages of India, in which now first language was classical languages also there. First language was there in Tamil. Okay. Then Sindhi was added in 1967 by 21st Amendment. Then Konkani, Manipuri and Nepali were added in 1992 by 71st Amendment, and Santhali, Methali, Bodo and Dogri were added in 2003 by 92nd Amendment. Now, in ninth schedule added by First Amendment in 1951 contains acts and orders related to legislature dealing with land reforms and abolition of zamindari system, and it is meant to protect the laws, including the judiciary scrutiny on the ground of violation of fundamental rights. Then these are not open for judicial review. Then 10th schedule is related with 50. It is added by 52nd Amendment in 1985, contains provisions of disqualification of ground of defecation. It means anti-defecation law is there in 10th schedule. And 11th and 12th schedule are really important. 11th is related by 73rd Amendment Act in 1992, contains provisions of Panchayati Raj, and by 74th Amendment in 1992 contains provisions of municipal corporation. Parts of constitution I am going to discuss, very important parts I am going to tell you only. Part 1 is deals with territory of India, formation of new states, and alteration and names of existing states. Then part 2 deals with the various rights of citizenship. It means citizenship is there in part 2nd. Part 3rd deals with fundamental rights of Indian citizen. Then part 4th is related with directive principles of state policy. Part 4th A is added by 42nd Amendment Act in 1976 contains the duties of the citizens. Then part 5th deals with the government at the union levels, and PM, President, Attorney General, Lok Sabha, Rajya Sabha and all. Then very important, in part 7th of Indian Constitution deals with the states what was deleted in 1956 by 7th Amendment Act 1956. Okay, then part 8 deals with union territories. So which part deals with the union territories? That is part 8, article 239 to 241. Then part 9 have two parts added by 73rd Amendment Act 1992 related to Panchayati Raj, and added by 74th Amendment Act 1992 schedule 12, that is related to municipalities. Part 10 deals with scheduled and tribal areas. Part 11th deals with relation between union and states, and part 14, that is really important, part 14 308 to 323 articles. These deals with UPSC and Public Service Commission. Then part 14A, Article 323A and 323B, added by 42nd Amendment Act in 1976, deals with administrative tribunals set up by Parliament to hear disputes and complaints regarding union, states and local government employees. Then part 15 deals with elections, or you can say also election commission. Very important part is there. Part 18th, Article 352 to 360 deals with emergency provisions. Then Part 19th, Part 19th, not Part 20th. Part 20th deals with amendment of Constitution. It is Article 368. Now it's important to talk about preamble to the Constitution. The objective resolution proposed by J.L. Nehru and passed by Constituent Assembly ultimately became the preamble. Okay, the idea of preamble was borrowed from the Constitution of USA. The words socialist, secular and integrity were added by the 42nd Amendment in 1976. So I'm going to give you a small idea of the preamble. We, the people of India, have solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all citizens justice, social, economic, political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves to this Constitution. Preamble is non-justicable in nature, like the directive principles of state policy, and cannot be enforced in the court of law. Our preamble is somehow based on Sarv Dharma Sambhav. Now, borrowed features of the Constitution, that is really important. So, from UK, what are the characteristics we have borrowed? Like nominal head, like president. Then they're like queen. Okay. Then from UK, we have borrowed cabinet system, ministers, post of PM, parliamentary type of government, bicameral parliament, single citizenship, speaker of Lok Sabha. And then parliamentary privileges also borrowed from UK. Now turn of US. What we have borrowed from US: written constitution, executive head of state known as president and is being the supreme commander of armed forces. That is also borrowed from US. Then vice president as the ex officio chairman of Rajya Sabha. That is also borrowed. Then fundamental rights, Supreme Courts, provision of states, idea of preamble. Removal of Supreme Court and High Court judges somehow borrowed from US. Now from Irish Constitution, what we have borrowed from Irish Constitution, we have borrowed concept of directive principles of a state policy, and you can say Spain's also their method of election of president. Then from South Africa, we have borrowed procedure of constitutional amendment and election of members of Rajya Sabha. Then Weimar Constitution of Germany, we have borrowed suspension of fundamental rights during emergency. Then from Japan, we have borrowed law on which the Supreme Court function and concept of procedure by law. Then from Australia, we have borrowed concurrent list, language of the preamble, and joint session of two houses of parliament. That is borrowed from Australia. And the last one, USSR. From USSR, we have borrowed fundamental duties and 5-year planning. Keshwanand Bharti versus the state of Kerala's case that was done in 1973, that gives the basic feature theory. Okay, so thus the Honorable Supreme Court held that basic elements or features of the Constitution as contained in the preamble cannot be altered by any amendment under Article 368. The another case of Supreme Court overruled the Berubri opinion of its own. In this case, preamble was not considered as a part of constitution, but in S.R. Bomai case in 1993 and LIC of India case 1995, Supreme Court again held that the preamble is an integral part of the constitution. Now it's time to discuss the union and its territory. Article 1 of the Constitution says India, that is Bharat, shall be a union of states. Integration of princely states done by Hyderabad and Junagadh and Kashmir by Sardar Vallabhbhai Patel. In 552 princely states situated within the geographical boundaries of India, 549 joined India, and the remaining 3 Hyderabad, Junagadh and Kashmir refused to join India. However, in course of time, they were also integrated with India. Hyderabad by means of police action, Junagadh by means of referendum, and Kashmir by the instrument of accession. The formation and alteration of states is dealing in Article 2, and the Constitution further states that a parliament has the power to increase or diminish the area of any state or alter the boundaries of or any name of the states, not to be considered as amendment of the Constitution under Article 368. What would we not consider? Like in Article 4 itself declares that laws made for admission or establishment of new states and formation of new states and alteration of areas, boundaries and names of existing states, these are not considered as the amendments. Okay, so if you change any state's name or any territory or any area name, that will not considered as amendment. Okay, the Indian territory can be ceded to a foreign state only by amending the constitution under Article 368. Consequently, the 9th Constitutional Amendment Act 1960, reorganization of states, S.K. Dhar Commission in 1948 to study the issue, and because of his administrative convenience, the creation of linguistic provinces committee by Congress in December 1948, and it will examine the whole question afresh. It consisted of Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitamaraya, and hence was popularly known JVP committee. The JVP committee, J means Jawaharlal Nehru, V means Vallabhbhai Patel, and P means Pattabhi Sitamaraya. Then it rejected language as the basis of reorganization of states. But in 1953, first linguistic state known as Andhra state was separated. Then created, you can say. The creation of Andhra states intensified the demand for other regions. Then Fazil Ali and K.M. Panikar and Achan Hungru, two members, they are the three member of these members submitted the report in September 1955 and broadly accepted language as the basis of reorganization of states, but it rejected the theory of one language, one state. 14 states and 6 union territories were created on November 1, 1956. Then what are the names? You can say Gujarat and Maharashtra created in 1960, Kerala 1956, Karnataka 1956, then Nagaland 1962, Haryana 1966, Himachal Pradesh in 1970, then Meghalaya in 1971, Manipur and Tripura in 1971. So it means Meghalaya, Manipura and Tripura, these are created in 1971. Then Sikkim in 1975, Mizoram and Arunachal Pradesh, these are created in 1986. Then Goa in 1987, Chhattisgarh 2000, Chhattisgarh, Uttarakhand and Jharkhand, these are in 2000, and in 2014 Telangana state was created. United Province was the first state of to have a new name. So what is the rename of this United Province? That was Uttar Pradesh in 1950. In 1969, Madras was renamed as Tamil Nadu. Similarly, in 1973, Mysore was renamed as Karnataka. In the same year, Lakadev, Minikoy and Amini Dev Island were renamed as Lakshadweep. Then Delhi was the capital territory of India, and this in 2006 Uttaranchal was renamed as Uttarakhand, and in the same year Pondicherry was renamed as Puducherry, and in 2011 Orissa was renamed as Odisha. The Constitution deals with citizenship from Article 5 to 11 under Part 2. A citizen is a person who enjoys full membership of community in which he lives. Single citizenship, no state citizenship is allowed. Okay, so Article 15, Article 16, Article 19 and Article 29 and 30, these are the provided rights of the Indian citizen. Then Citizenship Act 1955, and that was there. And then it has some amendment like 1986 amendment and 1992 amendment, 2003 and 2005 amendment. It can be you can acquire the citizenship by birth, by descent, by registration and by naturalization. Loss of Indian citizenship under the Act of Renunciation, Termination and Deprivation. Renunciation means त्याग देना कुछ भी, and then termination by terminated by government or by any other authority, and then deprivation means hani ho jana. Okay, foreigners of Indian origin, it does not allow dual citizenship. The Constitution of India does not allow dual citizenship, simultaneously holding Indian citizenship and citizenship of foreign country. But the government has granted overseas citizens of India (OCI) cardholder status to the persons of Indian origin. Overseas citizen of India cardholders, except from Pakistan and Bangladesh, these are eligible to apply under OCI as a person of India. OCIs are entitled to multiple entry, multiple purpose, lifelong visa. They are not entitled to hold constitutional post, employment with the government, and they cannot vote. Now it's time to understand fundamental rights. So here in fundamental rights, part 3rd, article 12 to 35 is named as Magna Carta of India because it deals with fundamental rights: right to equality, article 14 to 18, right to freedom, article 19 to 22, right against exploitation, article 23-24, right of freedom of religion, article 25 to 28, cultural and educational right, article 29 and 30, right to property, right to property, Article 31 was deleted, and then right to constitutional remedies, seventh right, which is mentioned in Article 32. However, the right of property was deleted from the list of fundamental rights by 44th Amendment Act 1978. It is made the legal right under Article 300A in part of 11th, in part 12th, part 12th of the Constitution. So at present there are only 6 fundamental rights. The difference between fundamental rights or legal rights, you can understand that a fundamental right is one in which Supreme Court can be approached directly, can and while ordinarily legal rights may be changed by legislature in ordinary, then they cannot be amended by any process shorter than that required the amending of Constitution itself. Then some cases are there. Central Supreme Court at loggerheads, like Golaknath case. In the Golaknath versus State of Punjab case 1967, the Supreme Court held that Parliament could not amend the fundamental rights under Part 3 of the Constitution. The Parliament, on its part, through 24th Amendment in 1971, assumed for itself the power to fundamental rights. Power to amend fundamental rights. In 1973, the Keshwanand Bharti and State versus Kerala State case happened, in which the basic feature theory was enumerated. Then in 42nd Amendment, under which amendment the scope of amending power of the Parliament under Article 368 was extended to many parts of the Constitution. Also, the constitutional amendment were placed beyond the purview of Supreme Court's power of judicial review. Minerva Mills case. In the Minerva Mills case of 1980, the Supreme Court tried to nullify the provisions of 42nd Amendment of the Constitution, and held that there could be any amendment in the basic structure of the Constitution is not allowed. Now it's turn to understand. The state may deny some of the fundamental rights to a class of people, as armed forces, paramilitary personnel, police, etc., in the interest of administrative efficiency or national integrity. Except the rights mentioned in Article 20 or 21, President has the power to suspend the enforcement of fundamental rights. List of fundamental rights we have already discussed about. In 1979, the Morarji Desai government appointed the Second Backward Classes Commission under the chairmanship of B.P. Mandal, a member of parliament, in the terms of Article 340 of the Constitution, to investigate the conditions of socially and educationally backward classes and suggest measures for this advancement. The Mandal Commission submitted its report in 1980 and identified as many as 3,743 castes. The Commission recommended for reservation of 27% government jobs for the other backward classes, or you can say OBCs. So the total reservation for all amounts, SC, STs and OBCs, amounts to 50%. On October 12, 2005, right to information was made at Constitutional Act because of the efforts of Aruna Roy, with the hope of an era to better, more transparent, accountable and responsive governance. It marks a significant shift for Indian democracy, with greater access to citizens to information and greater responsiveness of government of the society. Right to information is an corollary of fundamental rights of freedom of speech and expression. Article 19A. A strong and independent information commission has been set up at the center on the pattern of Central Vigilance Commission, or you can say CVC. The Central Information Commission shall consist of one chief information commission, and not more than Central Information Commissioners, not more than 10 Central Information Commissioners. They shall be appointed by the President on the recommendation of committee consisting of PM and the leader of opposition of Lok Sabha, and a union cabinet minister to be nominated by the PM. The terms of this is 5 years. CVC's term is IC term is 5 years, and then it is not eligible for reappointment, and In Article 21, protection of life and personal liberty, no person shall be deprived of his life or personal liberty. Personal freedom is secured by the Constitution by the judicial writ of habeas corpus, Article 32 and 226. The 86th Amendment, Constitutional Amendment Act in 2002 has inserted in the Constitution a new Article 21A. It is stated that the state shall provide free or compulsory education to all children of the age of 6 to 14 years. Further, in Menka case 1978, the Supreme Court declared the following rights as the part of Article 20. So Article 21 in because of Menica case in 1978 have some more features like right to live with human dignity, right to decent environment, right to livelihood, right to privacy, right to shelter, right to health, right to free legal aid, right to speedy trial, right against handcuffing, right to travel abroad, right against bonded labor, right to fair trial, right to hearing, right to information, right to reputation. These are related with the freedom of you can say freedom of or a protection of life and personal liberty. A nine judges bench of Supreme Court headed by the then Chief Justice J.S. Khehar. J.S. Khehar ruled on August 24, 2017 that the right to privacy is a fundamental right for Indian citizens under the Constitution, mostly under Article 21 and additionally under Part 3. Thus, no legislation passed by the government can unduly violate it. Some forms of writs are there in Article 32. I'm going to tell you in very short form. Habeas corpus, to have the body, under what authority he has been imprisoned or detained, that is there. Mandamus means literally means a command issued by the court commanding a person or a public authority to do or a forbear to do something in the nature of public duty. The writ of mandamus cannot be issued against a private individual or body. Then quo warranto, an order issued by the court to prevent a person from holding office to which he is not entitled and to oust him from that office, literally means by what authority or by what warrant. Then prohibition, the writ of prohibition is issued by the Supreme Court or High Court to a lower court or tribunal, forbidding the latter to continue for proceeding of a case in excess of its jurisdiction. Thus, unlike mandamus that directs activity, the prohibition directly inactivity. Then certiorari. Certiorari is related the writ to issue by the higher court to a lower court after the case has been decided by it, quashing the decision or order. In short, while prohibition is available during the pendency of the proceedings and before the order is made, certiorari can be issued only after the order has been made under similar circumstances. Suspendentiality of fundamental rights. So Article 359, 44th Amendment Act 1978, the suspension of Article 20 and 21 has been prohibited under any circumstances. Now it's time to understand directive principles of state policy mentioned under Part 4 covering Article 36 to 51. They tell about the aims or that the state should strive to achieve. It is called as conscience of constitution. The idea has been incorporated from the Constitution of Ireland. Okay, they are a unique blend of socialistic, liberal and democratic and Gandhian principles. In the state of Tamil Nadu versus Lalabu Kaur by case in 1984, the Supreme Court held that although directive principles are not enforceable, yet the court should not avoid them. So here are some directive principles are Article 38 to secure and protect a social order which stands for the welfare of people. Article 39, the state will in a particular direct its policy towards securing adequate means of livelihood to all citizens, equal pay and equal work. Then Article 40 to organize village panchayat. Article 41 to secure the right to work, education and public assistance in case of unemployment. unemployment, old age, sickness. Article 42 to secure just and human conditions of work. Article 43 related with the promotion of cottage industries. Article 44 to secure a uniform civil code applicable to the entire country. Article 45 free and compulsory education to all children up to the age of 14. 86th Amendment Act 2002 it was added. Then Article 46 to promote with special care and education and economic interest for the weaker sections of the people, especially the scheduled caste and STs. Okay, then Article 47 to secure the improvement of public health and prohibition of intoxicating drinks and drugs. 48 is related with animal husbandry and a prohibition of slaughter. Then Article 49 to protect all monuments of historic interest and national importance. Article 50 to bring about the separation of judiciary from the executive, and Article 51 to endeavor to secure the promotion of international peace and security. Directive principles added by 42nd Amendment Act 1976. These are Article 39A, 39F, 43A, 48A. 39A, the legal system promotes justice on the basis of equal opportunity and will, in particular, free legal aid. Then Article 39F, childhood and youth are protected against exploitation. Article 43A, to secure the participation of workers in the management, and Article 48A, to protect the environment and to safeguard the forest and wildlife of the country. Directive principles added by 44th Amendment Act 1978. So that was added 42nd Amendment Act 1976. These are 39A, 39F, 43A and 48A. And in the 44th Amendment Act 1978, the articles were added. Article 38A. These are the state shall in particular strive to minimize the inequalities in income. Then added by 97th Amendment Act 2011, Article 43B talks about the cooperatives. Then the directive principles mentioned in other parts like Article 350 is also deals with primary education in mother tongue to the people of minorities, and Article 351 it will be the duty of the union to spread Hindi language. Article 355 it will be under consideration to appoint the people of scheduled caste and tribes in the union and state services. Now I'm going to deal with fundamental duties. Though the rights and duties of the citizens are correlative and inseparable, these fundamental duties were added by 42nd Amendment Act and 42nd Amendment in 1976 on the basis of Swarna Singh Committee report. This amendment added a new part, namely Part 4A to the Constitution. Though the Swarna Singh Committee suggested the incorporation of 8 fundamental duties, the 42nd Amendment Act including 10 duties. Presently there are 11 duties because of the it has one more duty in later on. So in Article 51A, what are these fundamental duties? Let's recap. To abide to the Constitution and respect its ideals and institutions, to the respect national flag and national anthem. This one is the first one. The second one is to cherish and follow the noble ideals which inspired our national struggle for freedom. Third one, uphold and protect the sovereignty, unity and integrity of India. Fourth one is to defend the country and render national service when called upon do so. Then fifth one is to promote harmony and the spirit of common brotherhood among all the people of India, and derogatory to dignity of women. Then the fundamental duty sixth number is to value and preserve the rich heritage of our composite culture. Then seventh number is to protect and improve the national environment, including forests, lakes, rivers and wildlife, and to have the compassion for living creatures. Then eighth number duty is to develop a scientific temper, humanism and the spirit of inquiry and reform. Ninth one is to safeguard public property and to adjure violence. Then the 10th one is to strive towards excellence in all spheres of individual and collective activity, so that the nation constantly rises the higher levels individual achievements. And the 11th was added, it shall be the duty of every citizen of India who is parent or guardian to provide opportunities for education to his child, as the case may be, what between the age of 6 to 14 years. This one was added by 86th Amendment Act 2022. 86th Amendment Act 2002. The addition of fundamental duties along with the expectation of fundamental rights limits the operation and free enjoyment of fundamental rights. Like the directive principles, the fundamental duties are also non-justicable. So this much is all about. In the next audio, we will deal with the all portion, parliamentary system, president, prime minister, and all. Whatever is left, I'll include in the next audio. Till then, take care. Thanks a lot. Bye bye.